I call the meeting to order. We have a quorum. Item number 1. Information paper issued since the last meeting. There is one. Is constituency boundary maps in respect of the 2015 District Council election. Paper number CB-2764/14-15. Item number 2. Items for discussion at the next meeting. Let's invite representatives of the CMAB to join us. We have with us the Under Secretary, Mr. Lau Kong-Wah, Principal Assistant Secretary, Ms. Helen Chung, and Deputy Secretary, Mr. Gordon Leung. Under Secretary, the next meeting will be on the 16th of March. What do you propose that we discussed? We propose 2 items for discussion for the next meeting. First is the legislative amendment in respect of the 2016 LegCo election. According to the MPCSC August 31st decision on the selection of chief executive on 2016 and the formation of the LegCo 2020, the decision was that the 2020 LegCo election is election method is to remain unchanged. For the 2016 LC election, it will continue to use the 4th election method, and we will, in relation to legislative amendment, listen to members' views, and we will introduce the amendments to the LegCo within this year. The second item is the works progress on review of discrimination ordinances by the EOC, the Equal Opportunities Commission. We are aware that they are conducting a review on the various anti-discrimination ordinances, and there was consultation last year. We would like to invite the Commission to go through the works progress with the LegCo in the March meeting. We will invite Mr. York Chow, the Chairman, to join us next time. Item number 3. Review on the subsidy rate of the financial assistance for candidates and the election expenses limit for the 2015 District Council election. We have papers number CB-2823/14-15-03, which is the administration's paper, and CB-2823/14-15-04 is the background brief of the LegCo. Under Secretary, would you take us through the paper, please? At the end of this year, the general election of District Council, DC, will take place. So in relation to the subsidy rate and the election expenses limit, we have conducted reviews. We're here to consult you about our proposal and to listen to your views. In relation to the subsidy rate, it will be based on the cumulative change of the CCPI for 2012 to 2015. And in relation to the election expenses limit, we will also take into account the cumulative, the estimated cumulated change of the CCPI. And the change will be implemented in the DC election in 2015. And we submit the proposal for your comments. Ip Kok Him and 3 other members. Sin Chung Kai, Emily Lau, and Claudia Mo. 5 minutes. Mr. Ip Kok Him. It's mentioned in the paper that there is going to be an adjustment. And it talks about the cumulative increase of CCPI between 2012 and 2015, which is 17.3%. So is it going to be on the basis of $12? After the adjustment is going to be $14 in terms of the subsidy rate. The election expenses limit will be dealt with on the same basis. After applying the change, it will be about $63,000 because it currently stands at $53,800. What about subsidy in terms of circular mail? Will there be any change in this respect? Undersecretary.
There are two questions. First, the composite consumer price index increased by 17.3%. That is an expected increase. We will look at the situation this year, and then the EXCO will make a decision, and that would be the final figure, and it will be tabled to LegCo for Secretariat. Then that would be the accurate figure. Now that increase percentage will be applied to the election expense limit. That will be multiplied to $12 and the $53,000 figure. Now the actual figures will be tabled to you later. And the postage-free amount, now for each candidate there will be a postage-free opportunity, and initially there were two, and later people thought one is enough. And at this election we will also have one occasion or one opportunity for postage-free deliveries of promotion materials. Now this will allow candidates, especially new candidates, to gain contact with the prospective voters. Now in para 3A it mentioned that there are two cases. One is that the elections are contested, and the other is where elections are uncontested. And where there is 50%, where there is contest, where the election is contested, that's 50% of the number of registered electors. And if the election is uncontested, where there's contested election, it's the rate multiplied by the total number of valid votes cast, and where there is no contested election, it's 50% of the number of registered electors. Now, as Mr. Yip pointed out, in para 3, we said that how the amount is to be calculated. There are three figures to be taken into account. We take the lowest of the three. Now, for the first amount, it's the rate multiplied by $12, or the number of 50% of the number of registered electors. But if the and the second figure is the 50% of the election limit, election expenses limit, and C is the actual expenses of the candidate. So we take the lowest of the three. Sin Chong Kai. Now I'm looking at para 3 as well. Now the PAS reply was also about this paragraph. Now, right now you increase by 17.3% the EL, that is increased to about $63,000. Now there are the figures B and C, 50% of that, of the adjusted figure. As for C, now, so actually A is the most important figure. That is the number by the number rate multiplied by the number of valid votes. Well, the mic didn't work properly. Now, so if you multiply $12 by 1.173%, there is actually no adjustment. So if we use 2011 figure as a basis, there's actually no change. You merely adjust for inflation. Now for the unconstituted elections, now you are actually providing more financial assistance. Usually the voting ratio is about 53%. So if you take the number of electors, actually about 30%. So where there is uncontested, the actual support is about 50%. So the logic is wrong. Whereas the where there is contested election is 60% multiplied by 50%. So I have 2 points of view. For the contested elections, that's where people spend more. Or for the uncontested election, you subsidize 50%, so you pay actually nearly all the expenses. Undersecretary, Mr. Sin is right. There are two sets of logic. First, for the $12 and the EEL. Now, the $12 and the EEL will both be increased in step with each other, so the logic matches. Now, as on the second set of logic, for the three figures A, B, and C, we take the lowest figure. So the situation that you mentioned may not arise. We will take the lowest of the three, so it will be A, B, or C. Next, Ms. Emily Lau. I'm also talking about ABC. The SCL government is most miserly. All along, people talked about how to help the political parties develop in other countries. The parties are paid according to the number of votes obtained. Now, here in para 3, it's based on the amount spent, but you subsidize them at the rate of the lowest of the three. Now, even if we take the highest of the three figures, the Treasury can still afford it. That's what I asked Mr. Lam Shui Lung. Now, you should look at whom you are assisting. Now, even if the amount is paid, this merely assists the candidate. so that he doesn't have to pay so much out of the pocket. It's not assistance to the party. Why do we take the lowest of the three? Is it that the candidates are not worth assisting? Perhaps I will speak first, and then my colleague will supplement. Now, on the assistance scheme, this is mainly for encouraging people to stand. It's not, as Ms. Lau said, that the candidates are not worth assisting. We want to encourage more political talent to run for the sake of constitutional development. At first there was no assistance, and then we increased the assistance. So that's the way it progressed. Now, as to why we don't pay the highest of the three figures, now perhaps my colleague will tell you about the history first. Mr. Lau, the DS. Now, as the Undersecretary said, now originally in past elections there was no financial assistance. In 2004 it started with LegCo, and if you look at the document, it says that the purpose is to encourage more publicly spirited candidates to run, and this will help the parties. And because we have taken into account factors relevant to the use of public money, this is the way it has worked out. Now, in 2004, one of the factors was that the two postage-free mailing exercises were reduced to one. And we provided financial assistance in order to provide greater flexibility. And in 2007, this concept was extended from LegCo to District Council. And then we considered that the modes of election are the same, so different political parties and groups get a fair amount of assistance. I'm saying that they have been miserly, but the answer is inadequate. Now, you reduce the number of postage-free deliveries to one, but how much is that worth? Now, of course, you provide this financial assistance, the political parties pay less. But if you do as other countries do, you would be paying more to you would be reimbursing the actual amount. You should provide more assistance to the candidates or even the political parties. If the candidates perform well, they should be able to get more assistance. The Deputy Secretary, I was mainly talking about the history. Now, if we take the subject more broadly, here we are talking about the EEL and the financial assistance how they are to be adjusted. But as for the future development, this may have to be discussed in other meetings. This has to do with constitutional development. Now, have you worked out what's the difference between the highest and lowest amounts? Well, of course they didn't calculate that. Now, perhaps the differences are not that big. This is more difficult. Now, I'll just give verbal response now. It's hard to forecast, because we cannot set an upper limit to the number of candidates. Of course, they have to get at least 5% of the vote of the electors, a number of electors. But if there's in a certain district there are 3 or 4 candidates, and in the future there's a 5%. So there might be 20 candidates who can run, each getting 5% of the vote, potential number of electors. So can I please provide some figures? Yes. Claudia Mo, I'm also concerned about the paras 3A, B, and C. Now, on the proposal to pay the highest of the 3 figures, now for the case where there is no contest, then you are merely providing them with a gift, because they may hardly have any expenses. Now, in A, you are not talking about 50% of those who actually vote, but 50% of the number of registered voters. So if there's no contest, they merely get paid.
And you see the disadvantage. A lot of people, as a result, will run in the elections. Well, that I do doubt. So I find that a bit strange. And in reply to Mr. Sin's question, you asked him not to worry. You said that it's not to just give him a gift. It's, well, either 50% of the registered electors or $12 per vote. And also B and C. But if it is uncontested, you don't have to actually canvass for votes. And you talk about the lowest of the amounts. So you actually force me to declare expenses. Say, for example, $1,020 for this and that. It seems that the logic itself is dubious. Of course, for some political parties, it's rumored that they have a lot of money to spend. But have you considered have you considered improving it? And I want to ask, the meter starts running on the day when you sign up to run, is that right? What about 2 weeks and a month prior to when you sign up for the election? Is there a retrospective effect? Because before, I see that in some cases people, before they sign up for the election, they have practically behaved as if they were candidates, but since they have not actually registered to run in the election, all the expenses incurred are not counted. Undersecretary. Well, if we change it to the highest, it will change the ecology of the election. Some people may decide to run simply because of the financial assistance. And when you say that because of our existing arrangement, some people are forced to incur expenses. But the thing is, before the registration is closed, you don't know whether there will be someone running alongside you. So you will take that into consideration. You won't be forced to spend. And in relation to the retrospective effect, the calculation of election expenses does not necessarily start on the day when that person signs up to be a candidate. Maybe 2 weeks, 2 months before the person signs up as an elector, and that person has announced that he's going to run, the meter will start running. Well, but the thing is, they may not officially announce that they are going to run. Everything is implicit. I don't really understand what you mean. You do? If that person has not announced to run, then the calculation of election expenses will only start on the day when he registered as a candidate. And if we are to set 2 weeks or 2 months prior to that, well, I would like to know what justifications you have. Ms. Mo, I do understand that there are difficulties. Please consider what I said. Any other questions? Mr. Ipkokim? Thank you. I'd like to clarify a number of things. In an uncontested election, it's actually very simple. If there is no election expenses incurred, then that person will not get anything. Don't think that you will get $12. It won't happen. Because you have to consider all of the three amounts. Yes, we perhaps should consider making it the highest because it will encourage more people to run. But you may get 58% of the votes, or some may only get 15%. You may not get $12 times 85% of the votes, because it may be 50% of the election expenses limit. Well, I would like to hear from the administration whether they would consider making it the highest of the amount. I don't know if some members have actually been in an election because they are not very clear about it. Mr. Lau will look into it. Even if the highest amount is used, there may be some negative effects. Any other questions? It seems that some members would like you to get more to alleviate the financial burden of candidates. And there are also views asking you to change it so that more people will be encouraged to run. Well, actually, the 17.3% is not an actual increase in financial assistance because of inflation. In any event, please consider all the points. There are no questions. Let's go to the next item. Is the briefing by the Privacy Commissioner for personal data. Let's invite the Privacy Commissioner to join us. There are 2 papers. One is CB bracket 2823/14-15 bracket 05 is a paper from the Office of the Privacy Commissioner of Personal Data. The other one is the background brief of the LegCo. After the presentation of the Commissioner, I will ask members to ask questions. There is a PowerPoint presentation.
我哋歡迎
Welcome, Mr. Chang, Privacy Commissioner for Personal Data, and Chief Legal Counsel, Ms. Brenda Kwok, and from the CMAB, Deputy Secretary, Mr. Gordon Leung. Commissioner, you may start your presentation. Thank you. In my 5 years as the Privacy Commissioner, every year I came to the LegCo to report on our work. I believe that this will be the last briefing I give as Privacy Commissioner. I will give you a PowerPoint presentation for work in 2014. There are 17,000 inquiries made. Compared to 2013, a drop of 28%. And the different types of inquiries made, the most is just data inquiries related to direct marketing, and human resources management, collection of ID card, and also CCTV recordings. Compared to 2013, when it comes to internet-related inquiries, there is a sharp increase. In 2013, there were 425 cases, and in 2014, it has jumped to 611 cases. We also reply to major issues of departments. In 2014, in relation to the bills and regulations, we have made some comments. We have spent most time on the Electronic Health Record Sharing System bill. We came to the Bills Committee to exchange views with members. We're happy that most of our suggestions have been responded to in a positive way. In relation to complaints, in 2014, there were 1,702 compared to 2013, a slight drop of 5%. Of the complaints received, most of them are private organizations, about 74%, and there are also public sector government departments, 10%, and the remaining 16% against individuals. Among the private sector organizations, most of them are financial companies, property management companies, and telecommunications companies. And most of the complaints relate to the use of personal data without the consent of data subjects, about 41%, to be followed by the purpose and manner of data collection, and after that, data security and data access and correction requests. And in relation to direct marketing related complaints in 2013, there was an amendment to the ordinance, so the number of cases was a record high. And in 2014, the number of complaints has dropped from 538 cases to 277 cases. We conducted a survey, and we understand that most of these direct marketing activities are unsolicited direct marketing calls using personal data, some without. And we see a new trend. Most of these calls are related to personal loans, allegedly made by some banks. But if these calls were followed up on, the subject will find that it's actually not the bank they first claimed to be. And there are 8-digit numbers from outside Hong Kong, starting with a 2 or a number 3. When we refer some of the cases to the police, we found that there are a number of difficulties.
We think we need to take a two-pronged approach. Now, apart from the Commission, we should also work with the police and with the and also the OFCA. They have a register of those who do not wish to receive marketing calls, and we have understood that the Economic Development Bureau will follow this up, and in the middle of the year they will conduct a survey to get the figures and facts, and they will supply a report to LegCo in the second half of the year on the proposed strategy. Now, apart from direct marketing calls, there are also complaints related to information communications and technology and ICT, and there has been sharp increases in this category. Now, one reason is the use of mobile phones and internet having increased sharply. So the complaints relate to the use of mobile apps and social networking websites, and also disclosure or leakage of personal data on the internet and cyberbullying. Now, we also conduct compliance checks and self-initiated investigation. The sources of data are from the media and also from our own data collection, and now 47,000 persons are involved. Some cases involve hacking, and in some cases the organization's staff inadvertently disclose the data to third parties. In order to help the organizations to comply with the DPO, now we completed 217 inspections on compliance, and we investigated 120 cases, 102 self-initiated investigations, a sharp increase on the previous year, and we also came up with 2 investigative reports, and the recruitment advertisements and involving students, and also the labor department is also been the subject of our investigation, and we disclosed 5 reports in 2014 now, and we have listed the reports in para 19. We have seen a sharp increase in this area of our work. We think that we should share our findings with more people, and this has been very helpful for compliance. And we have launched a policy of naming those who fail to comply, and this has provided a lot of deterrence, and we will continue with that. Now, on enforcement action, in 2014 we issued 20 warnings and 90 enforcement notices, and referred the 20 cases to the police, and there was only 1 case of successful prosecution. There was an insurance agent who misled the Commission, and this was the first case of this nature, and where the penalty involved a prison sentence. Now, on the legal assistance scheme, that started in 2013, and within 2014 there were 7 new cases, and 8 cases carried over from the previous year. 1 case was approved, the others were either rejected or withdrawn by the applicants, and that includes 3. There are 3 cases still being considered at the end of 2014. And we have a privacy management program. Now, in our enforcement experience, we think that we shouldn't stop at compliance efforts. We think that the senior level people at the organizations should also be involved. So there should be policies throughout these organizations so that there is a safeguard of personal data privacy throughout the entire organization. And in 2014, we are glad that the entire government and 25 companies from the insurance companies, the 9 companies from the telecom sector, and 5 organizations from other sectors all pledged to implement this privacy management program. And the Hong Kong Association of Banks also indicated its support. And we next talk about Section 33 of the ordinance. Now, Section 33 is not yet effective. So where personal data is transferred overseas, there is only very weak protection. So in 2013, we already came up with a list listing out the jurisdictions which offer a same level of personal data privacy as Hong Kong, and we came up with a set of guidance for organizations to prepare for the eventual implementation of Section 33 on what they can do to protect data privacy. And these include recommendations, recommended model data transfer clauses to assist the organizations in developing the cross-border data transfer agreement with the overseas data recipients. Now, on promotion and public and education, we have this table with a lot of figures. Now, I won't go into the details. I'd like to point out merely that on the scope of activities and on the targeting of the exercises, we have both improved over the years. So the number of participants has increased sharply. Finally, on education, we issue a lot of guidance notes. In 2014, we issued 5 sets of guidance notes, and this provides a lot of education and encouragement, and so the information leaflets have also increased sharply. And I'd now also like to talk about enhancement of operational efficiency. Now, the volume of work has certainly increased sharply. In 2009, there were 1,001 complaints only. In the peak was 2013 because legislation was amended. There were 1,792 cases. This leveled off to 1,702, and you can see the increase in efficiency. That is, within 180 days, we were able to, where the number of the cases were dealt with within 180 days, that has been increased. That has increased sharply, and the number of cases remaining at the end of year has settled at a very low level. Now, on Section 39(3) of the ordinance, the PCPD now, according to this clause, if the PCPD decides not to initiate a formal investigation after inquiries into a complaint, he has to notify the complainant within 45 days after receiving the complaint. Now, this poses a lot of pressure because we need to look at the nature of the case. We need to contact the complainant or the party being complained against, or even third parties, before we can arrive at the conclusion whether there should be a formal investigation. Now, in some cases, it's impossible to complete this process within 45 days. Now, if we make a hasty decision just because of the 45-day requirement, this is very harmful for our efficiency or for fairness to the parties concerned. So we do not intend to mechanically adhere to the 45-day requirement for decision. At the same time, we are not giving up on this time constraint. So in 2014, starting from 1st of July, we started a performance pledge. So we require internally that 75% of the cases should reach this 45-day target. That is, the notice to the complainant should be provided within 45 days. And we were able to achieve a rate of 77%. We are confident that we will do better in 2015, so we have raised the target to 80%. But over the long run, in order to avoid unnecessary or administrative problems, we think we should resolve the matter by deleting this 45-day requirement from the legislation. So we have proposed it to the government, and the government has promised to follow up. And finally, on the strategic focus for 2015, of course, in enforcement and promotion and education, we will continue to work hard. But the main focus will firstly be on the privacy and data protection issues associated with the prevalent use of mobile apps. Secondly, we will conduct a survey on the public perception of the PCPD and various topical privacy issues. Thirdly, we will conduct a survey on the protection of personal data contained in public registers maintained by the government. And fourthly, we will assist the government and the private sector in administering privacy management programs. And fifthly, we will assist the Bills Committee in the deliberations of the Electronic Health Record Sharing System Bill as they relate to privacy and data protection. Thank you, Chairman. Thank you, Mr. Chang. 5 members have raised their hands. Mark May Kuhn, Chan Chi Chun, Kwok Ka Ki, Chang Lai Wan, Sid Ho, Emily Lau. 5 minutes each. First, Alice Mack. Now, in the Commissioner's report, he mentioned that there are some telemarketing efforts that involve deceit. Oh.
I had a meeting with the Commissioner about direct marketing calls involving deception cases. When we met, we gave him 19 cases involving possible leak of personal data. Within a week, investigation started, and they have reached all 19 victims of the cases. It's very efficient, so I'd like to commend them on their work. When we met, the commissioner said that government departments may have public registered available for the public, and they've been used by, say, some money lending institutions for their own use. Well, I'd like to ask about the work for the next year of the commissioner. Any plans? You also talk about the do not call register. You said that it should also cover person-to-person calls. You appealed to the CDB to extend the register to person-to-person calls. Well, the Bureau indicated that they were not happy to have it extended. What more have you done? What can be done so that members of the public don't have to receive so many of these cold calls? You said at the outset that it may be your last time to come to us for the briefing. And we've read from the press that there is open recruitment. Perhaps you have offended someone who is very petty, and that's why you will not be asked to stay. Well, instead there is an open recruitment. Well, do you really want to stay? We see that you have done a lot in personal data protection, and of course we would like to see your work continue. And you've also written something in your blog. Can you tell us whether you have actually offended someone? Well, I thank Ms. Mack for her compliment. Well, in 2015, we have plans to focus on this registered. We have conducted a questionnaire survey among government departments. We would like to know more about administrative amendments to improve the situation. A number of years ago, when personal data was under the purview of the Home Affairs Bureau, there were guidelines for departments for them to comply with. The use of public registers should be regulated by legislation. We are in the process of a review. We will give the administration a report. We will give them comments and recommendations. So that's our plan. And you said that the CEDB wasn't happy about our suggestions to have the register extended. But it's not that case, because the office of the commission, our office is independent, so we are not subordinate to any government departments. We operate as an independent entity. We're concerned about nuisance caused by person-to-person marketing calls. We've conducted a review. We gave recommendations to the CEDB for them to be followed up. Well, we all, according to documents in the public domain, well, in the ITBP, there was administration's paper saying that in the first half of this year there would be a survey to assess the situation, and at the end of this year there will be a report, and that's what we understand from public information. And in relation to the recruitment of the new commissioner, is an arrangement of the administration. Well, I believe that if they have any response, it will be better than mine. So, Mr. Leung, will you give us a reply in this regard? We've always adopted the way of an open recruitment for the commissioner. We've just adopted the old practice close to the time when the term of the incumbent commissioner ends. We would start an open recruitment. Mr. Ray Chan, about cyberbullying, there is an increase of close to 5 times. It's quite serious. You're talking about internet profiling. That is making public the personal information of a person. Some people don't really understand what is cyberbullying. Say, for example, personal particulars, where you work, your name, your measurements, and your age is made public. And in some cases, it's even worse. Your past romantic affairs and your employment record has been made public. What about the number of enforcement cases? Because we don't see information in this regard. My second question is about Section 33. We've been talking about Section 33 many years. Since it's not in effect, personal data has been transferred outside Hong Kong, and the law cannot deal with it because Section 33 is yet to come into operation, and the administration has turned a deaf ear to it. So in relation to this section, what are your concerns, and can the administration address the issue? So at what stage are we? Commissioner, first, cyberbullying. In 2014, the number of cases has increased compared to figures in the past. And a guideline was issued as a result. It's not just about privacy. It may involve criminal intimidation or infringement of intellectual property or defamation. We talk about the complexity of the issue in the guideline and what the Commission can do. Under the PCPD, under the PDPO, there are provisions in relation to the use of personal data because under one of the personal data principles, unless with the consent of the data subject, the use of data collected should be the same as that during the time when the data is collected. If it's something between friends, then the ordinance does not apply. But if information is collected without the consent of the data subject, it may be a breach of the personal data principle. And in some, maybe information is in the public domain, and some people may think that it's up for grabs since it's in the public domain. But you have to look at the original reason why it was in the public domain. Say, for example, it's used in a vehicle registration. It's not for any other purpose, say for example to find out who the vehicle owner is, and the information is used for other improper use. This is a breach of data protection, personal data protection, and we will issue an enforcement notice. The remedy has to be put in place, and maybe the personal data will have to be removed. And if it's more complicated than that, if it involves a criminal element, say criminal intimidation, then perhaps it will involve, you need to involve the police as well. What we focus on in our publicity and education is a proper personal data management, because prevention is better than cure. Some youngsters, they may be careless when it comes to making available their information on the internet, and before doing so they should think twice about it, because if it's been used improperly, it may have very serious consequence. Section 33 may not be in effect, but data being transferred outside Hong Kong is regulated in other aspects by other legislation. Say, for example, when the use of personal data should be the same as when data was collected. And security of data when transferred outside Hong Kong is also regulated by other provisions. Section 33 itself is very stringent. Transfer of data outside Hong Kong is strictly forbidden unless under specific circumstances. It's not yet in effect. It doesn't mean that the transfer of data outside Hong Kong is unregulated at all. Dr. Kaki. Well, lots of people say that Mrs. Carrie Lam is actually a very good fighter, but I heard that the commissioner actually is a very good fighter indeed. He's very good with karate. That was a report that was published last year. It was indeed very good. It's in relation to direct marketing course, and at that time, Mr. Greg So gave you a letter expressing his dissatisfaction. I think it was very well handled by you, because you did not succumb to pressure. You don't have to listen to him. And you did not give up simply because there was intervention from a high-ranking government official. Well, as we all know, when you took office, you were mired in some issues related to your time in the post office.
I'd like to ask the Deputy Secretary. We know that the PD performed well, and he should be in a well positioned to apply again. But one of the vetting committee members is the Secretary for Commerce and Economic Development, Mr. Gregory So. That is worrying, because we won't mind if there is an impartial official, but the Secretary openly issued a letter to criticize the work of the Commissioner. This is not acceptable for the public, because government departments do not have the power to override other organizations, and they also need to safeguard personal data privacy. Now, we have all been subject to these nuisance calls, including I myself. Now, the term of the Commissioner is up. If we continue to let Mr. So sit on the vetting committee, maybe that's inappropriate. Also, in the Occupy movement last year, now in the Alliance for Anti-Occupy movement. Now, some personal data of students, etc., were put on the internet, and at the time, complaint was made to government. Now, I'd like to ask the Commissioner, now this is over the 40-day limit. Now, should someone be prosecuted in this case or investigated? Now, concerning the Occupy movement, we have received complaint about cyberbullying or internet profiling. Now, we have dealt with all these cases, with the exception of one. By dealing with them, I mean, well, in most cases of these complaints, there was no complainant. Someone learned about this, but he was not the complainant, and he merely referred the data that he obtained from the media, and he referred the data to us. So he is not a party to the complaint, or sometimes they didn't tell us whether they were the aggrieved party. But there was one case where we actually were able to identify the aggrieved person, and he suffered invasion of his data privacy, and facts were supplied, and we were able to investigate in depth, but the findings are not yet available. Why is it that the findings are not yet available? I think it's more difficult in that case, because we have to understand that it's very difficult to identify the person who disseminated the data on the internet. Now, we asked the telecoms company to cooperate. Sometimes the telecoms company asks us whether we have the power to demand to know the identity of the person. So we need the cooperation from third parties. If we cannot identify that person, we cannot continue with the investigation. So that's where the difficulty lies. The Deputy Secretary, can you say something on that? Now, as I said, when we go about recruiting the commissioner, we adopt the fairness and the open principles. Now, as for Mr. So, sitting on the vetting committee, his scope of work includes IT and commerce, and so these are issues that need to be considered in recruitment. Now, as for person-to-person telemarketing, the commissioner talked about that. Now, the CEDP also conducts studies and follow-up. Ms. Cheng Lai-wan, I'd like to ask the commissioner now on the time limit for where notice for notice of not investigation. Now, usually not investigating. Now, usually you should notify that person that there is no investigation within 45 days. It seems that the commissioner wants to delete this requirement. Now, are you afraid that you can't complete the investigation within 45 days? So you don't want to have a very hasty investigation? In that case, is it better to extend the time limit to 65 days or 70 days? that would be better than deleting such a limit, because otherwise people will have to wait indefinitely. Now, we do have our difficulties. This is not a hasty decision. We have to decide that we won't formally investigate. We have to make that decision within 45 days. After our decision is made, they can appeal. They can appeal up to the level of EXCO of the. We have to provide formal basis to explains our decision, so that if the person wants to appeal, he can proceed on the basis of our grounds. And this statutory time limit is a very strange one. We have studied whether other organizations have such a limit, but the other organizations like the Ombudsman and Equal Opportunity Commission do not have such a time limit, and nor do our counterparts abroad. Now, if you want to use a statutory provision as a regulatory tool and demand the decision to be made within 45 days, you cannot achieve that in all cases. Otherwise, the decisions will be very hasty, and we would be challenged by the person concerned. Now, and it may not, because also once we entered into formal investigation, a lot of legal provisions will apply. For instance, in 2014 there was a case where an insurance agent misled us, so it led to his imprisonment. So once one enters into formal investigation, everybody is very careful. Some organizations will immediately hire lawyers to respond to us, in response to us. So for them, it takes time, and they will need to expend resources, and we can't just say we will decide one way or the other within the limit, whatever happens. So we will try to comply with the 45-day limit as much as possible, but we don't target 100% compliance. Last year, we achieved a rate of 77%. In the coming year, we hope to achieve a success rate of 80%. That's what I mean. So you can extend the time and you can achieve 100%. Now, you already achieved 70-odd%. Also, you said that the EOC and the Ombudsman's office do not have this 45-day limit, but in the judiciary and in the law courts, they have time limits on what they have to complete within certain periods. So I think there was probably good reason why there was this 45-day limit. I thank the member for her follow-up question. Now, we also try to understand what's the intention behind this provision, but we were unable to find it. Now, nobody could provide the answer on what's the meaning behind. Now, we suppose that this is to goad us so that we are more efficient, but what I'm saying is that we simply cannot achieve 100%, even if we extend the limit to 120 days. According to our past experience, some cases take more than 120 days. Now, in some cases, we think that mediation is better way to resolve it, like inquiries on the right level of fee. Now, even if the case goes to the appeals committee, it's very difficult to say how much the amount of the fee should be. So if we set a statutory time limit, is not helpful to all concerned. Now you can increase from 45 days to 60 days or 65 days, and you can add another category, that is the commissioner may exercise discretion to extend the limit. Now I think that's better than abolishing the limit altogether. Next, Ms. Sit Ho. Just now, Mr. Leung, the DS, said that the process of recruiting the commissioner would certainly be open, fair, and just, but the most important principle is to avoid conflict of the role of the members of the vetting committee. Now, if the Secretary for Commerce and Economic Development criticized the commissioner in the past and they traded criticisms publicly, then you have a political appointee who will be a key person in deciding who will run this public organization. This is not fair and open. So I think the secretary should be replaced by someone who is familiar with IT and so on. Now, I'd like to ask the Commissioner two questions. First, in the past there have been criticisms, and now the PCPD's office deals with personal data more than infringement of privacy. Now, in which direction should you move? Perhaps this question can be answered first. I thank Ms. Ho for her question. Now, the ordinance is very clear. It's privacy of personal data. So our monitoring is also in this regard. Now, the complaints that we deal with also involve other areas such as infringement of personal data privacy, but we cannot follow up because the ordinance did not give us the power in this regard. What we are in contact with, what we come across is mainly, conflict with the media. It may not involve use of personal data. Now, this committee, this panel talked about stalking and there's a new trend, and that's new challenges arising out of technological advancement. In the past, it said that if you do not have the person's consent, you cannot use his data. When you collect the data, you must be according to law. But now IT is so advanced, so the people in the industry feel that it may not be possible to get the person's consent in all cases. Now, some think tanks have been giving this some thought, and one idea is that for large companies there should be a system of accountability. This should be written into the provisions for regulating them. Now, what is accountability? For instance, the EU has been studying this matter, and we can look at how the development goes in the EU. Now, we have been unable to do that due to some constraints in the past. Now, I think there should be more clarification on the functions of the PCPD. Now, on privacy, there is no clear legal provisions to protect that. Now, there should be clear provisions for that, and so that based on past complaints, now there should be legislative proposals. This is very urgent.
This is a comment. Next, Ms. Emily Lau. Just now, someone mentioned about the involvement of an accountable official in the recruitment of the next commissioner. I do think that there is conflict, especially when the secretary has criticized the incumbent commissioner. And I'd like to ask, is it the usual practice to have an accountable official to get involved in the recruitment of similar posts? Section 33 now is still not in operation. The commissioner said that it's not completely unregulated, but it's quite. If a private organization or a government department transfer data out of Hong Kong, what are the penalties? Without Section 33, we can only use personal data principles, protection principles. Say the purpose of the transfer. If the purpose of the transfer is not the same as the purpose of data collection, then it's a breach of the personal data protection principle. But it's not very effective. What we can do is to issue an enforcement notice. Actions will have to be taken in accordance with the enforcement. It's not as stringent as Section 33 because a breach of Section 33 is an offense. The penalty will be much heavier. So if it's in appropriate use, the current penalty is quite lenient. How lenient? We may issue an enforcement notice, and when the enforcement notice is complied with, there is no consequence. And if it's a breach of the enforcement notice, is a crime. It carries a maximum penalty of 2 years imprisonment and a fine of $50,000. But that's only in relation to not complying with the enforcement notice. But the data has already been transferred. Well, it cannot be undone. But it's also mentioned in the guideline. To put in place terms and conditions to control the use of the recipient. Say, for example, to stop the data being further transferred or request to have the data transferred deleted. If you receive a complaint, do you have the power to go to the organization, public or not, to look into the case to see if the data has been transferred outside Hong Kong? Where there is a complaint, we will definitely follow it up. But as I said, the maximum penalty is still limited. It may not be high enough a deterrent to protect personal data. No, my question was whether you had the authority to investigate. Do they have the obligation to answer questions for you to find out whether the data has been transferred? Yes, we have the investigation power. Have you received any complaints You may be a toothless tiger, but at least you can tell us how many complaints you have received in relation to transferring of data outside Hong Kong. I have not received any such complaints. Well, this section will have to come into operation as soon as possible, and members of the public should be encouraged to go to you because you have the investigative power. Organizations will have to tell you whether the data is transferred outside Hong Kong. Yes, inquiries will have to be answered. But when it comes to transferring of data, since Section 33 is not in operation, data can be transferred outside Hong Kong. Mr. Leung, please answer Ms. Lau's question. As I've explained, Mr. Greg So's participation in the recruitment exercise, we don't see any conflicts. Well, we'll have to consider if the candidate is possesses the relevant expertise and qualifications required. My recollection is that at that time it was about person-to-person calls. It was only a discussion, so there is no conflict of roles. And I'd like to supplement about Section 33. The government is working closely with the Commission. To look into what work will have to be done if the section is in operation. Say, for example, the white list. The government has plans to engage a consultant to conduct a business impact environment of Section 33. Another thing the consultant will look at is whether all the conditions are in place for organizations to comply with the section. Next, Dr. Fernando Zhou. Well, I am also concerned about the open recruitment exercise of the post of the Commission. When you first took the post, a number of bodies asked about the selection process. It is not compliant with Paris Principle because your post is related to human rights. The Paris Principle requires the selection to involve an independent selection panel with representatives, with people who are broadly representatives and who know about human rights. Say, for example, representatives of the civil bodies and human rights groups. The selection process should be transparent. Candidates should participate in open fora to express their views about the post as the commissioner, as the privacy commissioner. Will the administration select the next commissioner in accordance with the Paris Principle? And about the right to forget. EU court has decided that for Google, if a person may apply to have the hyperlink delete if the information is excessive and if it's irrelevant. The Commissioner has expressed his views. I don't know whether the Commissioner will circumvent the legislative and introduce the right to forget by legislation. Well, we're quite concerned. I don't know whether Google will introduce this right to forget or right to be forgotten in Asia Pacific or Hong Kong. Well, first of all, in relation to legislation, it has to be done by the administration. We don't have the power to do so. Of course, we may give comments. And about the right to be forgotten, we don't think it's the right time to take action, because this is a new concept and is still uncertain in the EU. We'll keep track of its development and consider how Hong Kong should respond. At this stage, it's just an EU court decision. It's not binding in Hong Kong. Our interpretation is that Google search engines is not data users as defined in our legislation. But we can't rule out the possibility that there will be legal challenges. But this is just a preliminary view. Well, there is no huge pressure for it to be introduced in Hong Kong. It's just the beginning. We can have a discussion first and encourage views to be expressed before we take another step forward. When it comes to the right to know and freedom of information, well, the EU court decision is not an absolute power. Decision will have to be made having taken into account the case itself. There are concerns that celebrities may want to use this right to be forgotten to have some dubious history of him or herself deleted. The EU guideline is very clear that the right to know will override the privacy of an individual. And if you use a name in the search engine, well, the hyperlink may be deleted, but the source information remains. It's just that you can use other ways to search. Say, for example, not the name, but some other names. You will still find the information. The information is still in the public domain. Sometimes some people, without getting a thorough understanding of it, think that when you make a request, it will be approved and the right to know will be undermined. Well, it's been 7 to 8 months since the EU court decision, and we found that the concerns expressed at the beginning were just on the excessive side about the Paris Principle. We don't think the Paris Principle applies to the Commissioner. The principle is in relation to human rights organizations or bodies, and so it may not be entirely applicable to the Commission. And we conduct the recruitment in accordance with the PDPO. Mr. Charles Mock. Some members mentioned about the open recruitment of the post of the commissioner. I've commented on this. I've said that the commissioner has been very hardworking, and in the e-health record bill, the commissioner has given us a lot of valuable input. And the commission is also concerned with information technology. We may not see eye to eye all the time. Say, for example, cyber profiling and the right to be forgotten. Some people thought that you supported it. There may be issues that we don't see eye to eye to, but we understand that you at least are willing to talk.
I think that's very positive. Now, just now it's been mentioned concerning person-to-person marketing. I agree with the commissioner. Now, I may not support the same method, but I think the regulation should be stepped up. But I think it's problematic if the Secretary for Commerce and Economic Development is involved in the vetting of the commissioner's position, and especially when we hear that the SED has been saying that he's very busy. Now, on Ms. Emily Lau's question that Section 33 has still to take effect. Now, many people in the IT sector, etc., feel that the section should become effective ASAP, but this is a legislative matter. Now, what the commissioner can do can only serve a stopgap purpose. Now, perhaps this is not a matter for consultation. Maybe this section should become effective ASAP. And the last round of consultation was a long time ago, whereas IT has been progressing very rapidly. Now, so also I'd like to ask the commissioner. The previous commissioner often comes to this panel, even though I wasn't here at that time, and the commissioner used to say that there wasn't enough resources. Now, I haven't heard this so much from you, Mr. Commissioner. Do you want to get more resources so that the public don't have to wait so long when there are complaints? The DS first, on Section 33, now actually the provision says that if personal data is to be transferred abroad, certain conditions must be met, otherwise it will be an infringement of the law, and there are conditions listed in the provision, and as the Commissioner said, the PCPD has done some work to establish those conditions. In that case, you mean it never has to be effective? The PCPD will be doing the stopgap work? Now, the Bureau is proposing to have a consultant study on the impact on the various industries, especially the ICT sector, once the Section 33 is implemented. Now, why do we want to do this due diligence? Because once the section comes into effect, if any organization cannot comply with the requirement and transfers data out of Hong Kong, it will be penalized. So we want to make sure that those conditions to be complied with are reasonable and that they should be broadly achievable so that people would not fall into a trap. Now, on the allocation of resources, we think that there are difficulties. Now, in the past few years, as you can see in the table, we try to add value with existing resources. Now, the government has awarded us larger budgets every year, but it's not enough. For instance, the government allows us 69 positions, but we are deploying more than 80 staff. Now, we can do this because for some staff right now, they are young and they are of low seniority, so we use the amounts allotted to us for salaries, and we can deploy more staff. But when they reach a certain seniority, and if we don't want them to move to other organizations, we do have a problem. For instance, we know that we will receive some funds for 2015 to 16. There hasn't been much increase in the budget. Now we know the largest item of expenditure, apart from salaries, is rental. Now I believe our rent will be increased soon. 10 odd years ago, the rental was $11 per square foot, and now it's $33. And within a year, there will be another increase. And the government hasn't made an adjustment to its funding for us. So we hope the government can help us in this regard in the future. First round, Hon. Chairman, I certainly understand it's very difficult to work without enough resources. When Mr. Chang came into office, I scolded him because he didn't do well at the post office. Now he's doing well, but he hasn't enough resources. Now he's going to step down soon, and he's only saying now that there is enough money. Are you asking that we should provide more resources? In that case, we will assist you. We will speak out. I spoke against you because he had some contravention at the post office. When you came into this position, I scolded you, and now you did right, so I try to help you. It's human nature. Now, when we want to safeguard personal data privacy, are we spending enough resources on that? Now, on costs, the rental is now almost 3 times as expensive per square foot wise. Now, it said that the Commission helps the government to implement Section III. Now, that's very important. Data would certainly be transferred abroad because it's cheaper to process the data outside of Hong Kong, say in India. Now, if it's English, the data can be transferred to India. If it's Chinese, it may be transferred to Guangdong. Now, people are worried because in the mainland and in India, how is personal data privacy protected? How is the data to be prevented from being leaked out? Because it's a different jurisdiction. How do you want the LegCo to help you? Now, we know there's a problem. We know you can't do it. Is it for lack of money, or is it that you do not have the legislative framework? the Commissioner. I thank Mr. Leung for his comments. Now, on adding value with our existing resources, that's what we have been doing in the past few years. And as I said, we have to increase salaries to keep the talents. And given the advances in technology, we should make the right preparations in our policies. We want to do the publicity and education before the new provisions come into effect. We want to work with the sector to make preparations, but given our current shortage of resources, we mainly focus our efforts on investigation and inquiries, the work that has to be done. Now, is this desirable? Certainly not. We hope to have more resources for us to do our work adequately. Now, you just described a very scary situation. Now, if we increase the resources, you will be able to do more. The law has given you the power to do more. You need to do more investigation. Now, if there is no increase in resources, then preventive work and liaising with people outside of Hong Kong, etc., cannot be done. So the more we ask you to do and the more you have to do, you need more resources. Otherwise, you can't do the work. So, okay, I'll get the money for you. Happy retirement. Next, Mr. Raymond Wong. Mr. Leung Kwok Hong praised you, but I will not, because this is your annual work report. As the monitoring body, I will not say very complimentary things. Now, have you offered value for money? Now, the PCPD received 1,702 complaints last year, 5% less, and it compliments itself on the seminars, advertisements, etc. There is nothing achieved. Now, in 2013 to 14, there's an increase in the problems. 288 cases were financial, and it's in first place every year. Now, the telemarketing for people to borrow money, that has persisted in the past few years. The LegCo is concerned, but the government is shunting its responsibility. The CDB has been working against us. Now, there are 694 cases of complaints of data being used improperly. I have a complaint too. Now, early last year, I reserved a ticket to go to Taipei at Cathay Pacific. Now, because of Occupy movement, I couldn't leave. I tried to change my ticket. Now, all the data appeared on the net. First, it was on the one magazine. Now, that magazine always treated me as an enemy. Now, I asked the head of the airlines. They found out that the data certainly came from them. They looked at the hard copy. The itinerary number shows that it's from them, but they couldn't find out which staff member made the leak because they had thousands of staff, and they said that I'm a public figure. Now, and the headline says Raymond Wong makes an escape to Taiwan. Now, of course, I'm a public figure. I don't care. Now, this magazine couldn't buy me, so maybe that's why they were upset.
What?
Well, I have almost finished with the complaint letter, but there's nothing I can do. I may be a public figure, but what about those who are not? There are 694 cases. The use of personal data without the consent of data subjects. It's used by the media. I can't take them to court. I can only curse Jimmy Lai. But what about the others? So, well, that means that there is no prevention at all. The protection is in existence. So, well, why? There are so many complaints. You now hear and you blow your own trumpet. I don't understand why Leung Kwok Kong has good words to say about you. Says 40% of them received calls, and 62% of them received calls addressing to them by name. And someone called me and called me and addressed me as Raymond Wong, but I don't know the other party. And you said that there are 20 cases referred to the police with no successful convictions. So I can't bring myself to commend you. I won't commend you simply because you are leaving your post. And about this new smart ID, about the RFID technology, you must be prepared to receive complaints, because your data can be read remotely. Well, before Mr. Raymond Wong spoke, they were just good words about the commissioner. Not the case close to the end. We still have about 3 members who would like to speak in the second round, but we only have 1 out of the 3 here. 3 minutes. If the others don't return, then we will end the meeting. Ms. Emily Lau. Just now, the DS said that the Commission is not a human rights group. But that's not what you said to the United Nations. The United Nations asked you to set up a Human Rights Commission. You said we have the EOC and the Privacy Commission. So actually, what are they? And about Section 33, the DS said that there is a study being conducted. One of the issues covered is business impact assessment. Well, a lot of our data has been transferred outside Hong Kong. You're going to see how they will be affected when they are no longer able to do so. If that is the case, you may cause panic in Hong Kong. No, what I said was, according to the Paris Principle, it's about national human rights institutes. Our understanding is that it refers to human rights covering different areas. And I try to explain that when it comes to the work of the Privacy Commission, it's not just about human rights. Section 33. We would like to ensure that the intent or the objective of the section can be achieved. The legislative intent is that when there is transfer of data outside Hong Kong, there should be sufficient protection. That is the object of the section. Under Section 33, transfer of data outside Hong Kong can be allowed in specified circumstances. We want to make sure that these are reasonable circumstances. And that we can strike a balance. Our understanding is that even without Section 33, for a number of the organizations, there is a certain degree of privacy protection. When Section 33 comes into operation, we would like to make sure that all organizations in Hong Kong are fully prepared to comply. We don't want a large number of litigations and disputes. The general principle is still protection of privacy. Ms. Lau. On a number of occasions, you have given human rights reports to the UN. When you're asked to set up a human rights commission, you said that in Hong Kong, these rights have been sufficiently protected. And that's why they mentioned Paris principle. In the recruitment of the new commissioner, please use this principle. And the criticism against Greg, so please, you have to mull over it. The last one, Ms. Alice Mack. Sorry, I was next door because there was no quorum. Well, the post of the commissioner can be reappointed once. So if Mr. Chang is willing, he can be reappointed. So does it mean that Mr. Chang has to apply in the open recruitment? Before you decide on the open recruitment, did you ask Mr. Chang whether he would like to be reappointed? Because there is still a lot of outstanding work. We are very concerned. We don't mean to interfere about the appointment of the head of a public organization. We are concerned whether there are a lot of petty-minded people. When they see someone doing something they don't like because they are petty-minded, then a letter will be given to that person. And in the future, people will be worried that if they do something, it may result in the end of their term. Are there any mechanisms to ensure that these petty-minded people will not be able to cause trouble, so that people who has the determination and the courage to do something different don't have anything to fear? And when it comes to telemarketing, it's about frauds. Mr. Chang says that they need the help of three different bodies, the CEDB and the police and the DOJ. But something has already been done by the police, but CEDB is not here and they have not done anything. Is my understanding right that no preventative measures can be taken because the Bureau itself is responsible for that? And the DOJ and the police are there to just enforce the law. Mr. Leung, do you understand what is meant by petty-minded people? Well, I don't really know. If you don't even understand that, then how do you know what is going on the internet? Well, I use that petty-minded people because there are too many petty-minded people in the government. We've adopted the same approach, just like past recruitments for the post of the commissioner. On a number of occasions, when well, actually every time there was an open recruitment. There is high expectation when it comes to an open recruitment of the head of a public body. They require transparency. That's why we have adopted this approach. You mentioned about telemarketing. As I understand, the Commissioner has already explained. When it comes to person-to-person calls, the Secretary has already reported in the panel that a study will be conducted on person-to-person cold calls. Commissioner, I thank Ms. Mack for the follow-up questions. Just now, Mr. Raymond Wong commented on the work of the Commission, and I would like to reply for the record. Well, he criticized us. It's not about me. It's about the work of the Commission as well. We don't find these comments fair because we have worked very hard and there are constraints and difficulties. Say, for example, infringement of privacy, say, for example, person-to-person calls. Before Mr. Wong entered, I have already said that this is a complicated issue involving different government departments. We need their cooperation before we can tackle it. And Mr. Wong himself has a complaint to make, and I'd like to say that we have a very sound complaint handling mechanism. Before we when there is a decision and if the person is aggrieved by the decision, there is an appeal mechanism in place. Figure shows that 90% of the appeals result in our decisions being upheld. Mr. Wong mentioned about person-to-person calls. We really would like to work with the relevant authority to do something different. Calls from outside Hong Kong are difficult to track, but we have some information, including information passed on by Ms. Mack. Caritas passed on information about similar cases to us. And we will arrange for a discussion as soon as possible with the DOJ and the police. But there are difficulties because of the Occupy movement. The police could not spare resources to talk to us. And we have changed our tactics. If they don't have the time to come to us, we will go to them. We explain to the police using their training sessions on areas that they can help us when it comes to telemarketing. Well, it's almost time. I remember I was one of your supporters when you were appointed. I'm glad that we were right. In any event, we don't know whether you'll be reappointed. And we hope that you will do better. And I wish you a happy New Year. On the 16th of March at 2:30, we'll meet again. Thank you.